Ben Lynde from our committee last year. Come on up. Now working with ACLU of Georgia. Welcome back in your new role.
Thank you, Mr. Chairman. It's a pleasure to be here in this new role as Policy Counsel for the ACLU of Georgia, the premier organization for protecting the civil rights and liberties of all Georgians. We're here today in opposition of SB 10 for many of the remarks, the same reasons that the senators have raised here today, mainly dealing with mandatory minimum sentences. Based on the research that we've been able to find from the Pew Research or the Brennan Center regarding the correlation between mandatory minimums and public safety, it's a public policy that takes the high cost, low reward framework of trading mistrust in public institutions, overcrowded prisons, and sentence inequity with minimal impact on violent crime or promoting public safety. We are here today to support the recommendations of the Counsel of Criminal Justice Reform when they recommended eliminating most, if not all, mandatory minimums in the state of Georgia for two principal reasons. The first is that they fill prisons and they promote sentencing inequities. The second addresses many of the concerns here regarding truth in sentencing, that when there are such high mandatory sentences placed without individual determinations of fault or the facts of the case, that only leads prosecutors to invent legal fictions in charge bargaining in order to avoid the mandatory sentences if it's going to result in an inequitable or overbroad sentence for these offenders. Another thing that I want this committee to consider is the fact that is our judicial system equipped to deal with the rise in jury trials that will result from this bill, where defendants have no choice but to take their cases to a jury trial because pleading guilty with this automatic 10-year kicker would not provide them any opportunity for a meaningful life on the other side of their prison sentence. Also, we want to take those concerns and weigh those against the minimal public policy benefits of mandatory minimum sentencing, where, especially in light of if the idea is to have the availability of harsher sentences, every single enumerated offenses that triggers the mandatory minimum 10-year, with the exception of two, already carry death or life imprisonment as an option for prosecutors. If these are cases where a judge or prosecutor believe that harsh sentences are necessary, that provision is already available to the judiciary. And that goes back to the fact, if it's not happening, it's because these prosecutors are evaluating the mandatory minimums that already exist, and they're evaluating it to the facts and trying to make individual determinations, and so maybe not charging the case appropriately under the law just to avoid unintended outcomes for these individualized defendants who don't deserve that amount of time on the other side. So while the ACLU of Georgia supports any measure that's going to promote public safety as a general rule, it is not necessary in this case with the already harsh sentences that for these offenses for us to impose a 10-year kicker, such a draconian mandatory minimum when the sentences are already there. We're here to ask the committee to follow the recommendations of the Counsel of Criminal Justice Reform, which was a years-long process that included distinguished senators, the now Chief Justice of the Georgia Supreme Court, district attorneys, judges, and other stakeholders when they evaluated that mandatory minimums were not working and were getting us into a prison crisis that we're only starting to see the resurgence of now again. So I thank you for your time, and I'll take any questions.
One question I have, assuming you agree that violent crime is on the rise and has been for some time now, if it's not this, then what are we doing wrong? What should we be doing from a criminal justice standpoint to address and to get what he's trying to accomplish?
I would take umbrage to some degree with the idea that there is a rise in violent crime. From every metric, and I do try to watch what's happening in the Atlanta Judicial Circuit, that when we look at crimes, we know the murder rate has risen somewhat, but all other crimes, at least for this year, have decreased from where they were at last year. I think that the pandemic definitely had some impact on crime, but we don't have enough data from a point showing a trajectory that there is a rise in violent crime. But accepting as true that there is, we know that Georgia punishes more people more harshly than any other state in the union. We have more people under community control than any other state in the union, and that's even on per capita levels. I think the only other state that imprisons more people than we do is Louisiana, but we still keep people up for more probation for longer. So if there is a rise in violent crime, it's not for the fact that we're not sentencing people to harsh enough sentence that's keeping crime down. If there is a different way, the smart on crime approach that people have looked at and what was recommended by the Criminal Justice Reform Commission is looking at community partnerships and way for community intervention to reach people where they are, because the fact that there's higher prison sentences is not getting pushed down to young offenders, because when we're talking about these crimes, we're talking about people who are young, who have no concept of what waits for them on the other side of the criminal legal system. So actually having those education and trying to invest in communities where people think that they have a future is probably way more effective than such draconian mandatory minimums.
And to be fair, Senator Beach, one of the things you mentioned I wrote down was about having education and public information campaign about our current laws. And I'm not sure if we're doing that now or how to effectively do that, but you have strong laws as we see here on the books. I don't know if that's being... And
then that goes on to the other side. If the laws are not already being followed, then what's the point of educating people about what the mandatory minimums when that's not being something that's actually followed by judges or prosecutors?
Senator Counsel.
Thank you, Mr. Chairman. So Chairman Beach's concern is this revolving door. These people, it seems to be that we keep reading about criminals that it's not their first offense or second. They've been convicted, they've spent time, and it's not working. What would you think if this bill got changed to where it was for repeat offenders only, which would directly address his problems? So let them get their normal sentence on the first time they break into somebody's car with a gun, but the next time, by golly, we mean business. Would that satisfy your concerns?
It wouldn't, and the reason I would say why is when we look at serious violent offenses, there are already so many provisions in the law regarding repeat offenders for serious violent felonies, where that I believe under 1710(7)(b, when we talk about sentencing for serious violent felonies, it's an automatic life sentence. And so if that's not what's addressing the problem, these enhanced criminal penalties, then I don't think that these adjustments to this law are actually targeting what the issue is. And no part of my testimony or answer here to the question is impugning the good intentions of this bill. If I want to live in a safe state and a state that allows for business to go on, I just don't think this is actually targeting what the issue is.
And maybe we can get more information on this, but you're saying right now if someone violates this code, I know this is already basically an enhancement section, I guess the right way of putting it. If someone commits one of these crimes twice, there's already is there a life sentence built in?
I would defer to legislative counsel if I'm wrong, but my understanding is under 1710(7)(b, the second commission of a serious violent felony requires an LWOP sentence.
Okay. Senator Jones.
Thank you, Mr. Chair. So my question is, when you were mentioning about the jury trial situation, that could cause actually more jury trials to occur because they have no choice at that point in time. So you might have someone who's willing to plead guilty, but now say, I got to go to have no choice but go to trial. Can you explain, number one, the impact that could have on the jury system itself, and then number two, to where you actually may start losing cases potentially because you have victims or witnesses who may not be able to come forward for various reasons, especially now if you have an increased backlog and it takes years before the case goes to trial?
I think it's worth mentioning at this point to emphasize how bad the problem with jury trials are in the state of Georgia right now, where there's still multiple circuits suspending speedy trial rights of defendants because they can't get to the cases they already have. So that's changing nothing. That's still the situation we're in terms of we don't have enough bandwidth with our defense attorneys and prosecutors and judges to get the jury trials done that we're trying to do now. But so if this bill comes up, I understand because I was both a prosecutor and a criminal defense attorney, and I know when defendants, if if it's a acquittal or nothing for them, because if they're facing down that long, and so many of these offenses are automatically under this bill would require 20 years to the door. And so for a lot of defendants, that's going to be their entire life before we even start talking about the time that they could be sentenced to on top of that. So the only option they have is to go to a jury trial. And I can also say that, when we start talking about the time that Superior Court judges spend on trials, it's largely these types of offenses. I think that this is the kind of bill that's going to create that positive feedback loop that's only going to exacerbate, the crisis in terms of having people able to comply with their speedy trial demands. And if you want to talk about the effect it has on victims, then we start looking, because while the state can suspend statutory speedy rights, we cannot suspend constitutional speedy rights. That's not a provision given to the legislature. So you have cases that have victims, and when we start talking about serious violent felonies, by definition, they're cases with victims. And so now, are we going to start pushing out, trials long enough where now, because it only takes a year of not having your jury trial for a presumption that your speedy trial rights have been violated under the Constitution, where now we've waited so long that these victims can never have justice because their cases are effectively time barred because of constitutional speedy demands.
Are any other questions from the committee? All right. Thank you, Ben.
Thank you very much, committee.